My name is George Parnham. I'm a criminal defense lawyer, board certified in the area of criminal defense by the State Board of Legal Specialization. And I was board certified in 1986 and then continue to re-urge or re-up the certification process. Today I want to discuss the issue of sex offenses or the allegations thereof, and talk about some of the pitfalls that a defense lawyer needs to be aware of when faced with the defense of an individual accused of this particular type of offense. Let me initially start by saying that an allegation of this fashion is the most egregious type of allegation one can possibly face. A jury will take a look at this, will make a determination based on a number of factors to include the credibility of the witness, but in all probability a jury will listen to a child, will understand what the child went through, may even have friends and relatives in the juror's past that have undergone these type of particular offenses. So it's important to understand that. The other thing that's so important is to realize that so many of these cases arise out of a family dispute, be it a formal divorce proceeding or just an allegation between two non-living together partners, husband and wife, ex-husband, ex-wife, because allegations of this fashion can carry with it, as I mentioned, the utmost concern and impact on the individual that's accused of this particular offense. It's absolutely vital to get you involved with an individual expert witness who has had previous involvement in these types of cases. That expert is going to view the video, make a determination based on the credibility of what that expert sees, and to be able to testify on direct and on cross-examination by the state as to his or her opinion about the credibility of the allegations of the individual. Not the credibility necessary of the individual, but to be able to poke holes into the credibility of the allegations of the individual who is pointing the finger at your client. So it's very important to understand that and to realize that there are many other factors that can be explored to go into the background to suggest the non-reliability of the person on the witness stand, not attack that individual's credibility, but to find other means and methods whereby prior statements, for instance, you are able to undermine or at least show the jury that what is being said is of no consequence. Obviously, if there's any type of physical evidence that comes into play, that's an enormous hill to overcome. When you have a child who has physical symptoms of having been sexually abused, that is a almost overwhelming fact situation. And therefore, when my associate Tom Abbate, who will talk to you about the offenses themselves and the possible defenses to those offenses, one needs to be aware that these particular types of offenses, unlike anything else, homicides, anything else, these types of offenses are egregious just because of the very nature of the allegation. And with that, I would turn you over to my trusted associate with Parnham & Associates, Tom Abbate. Tom?
And today I'm going to talk to you about sex crimes under Texas law. You will note that we've had a previous video regarding the defense of sex crimes. This is things regarding what you should be looking for in a lawyer, things of that nature. A link to that video will be down in the comments of this video in case you prefer to look at that one as well. Now, regarding the actual sex crimes, we've got different tiers under Texas law. They're all felonies, so they all carry at least some punishment range where there's the potential for incarceration. The other thing that you need to keep in mind is that they all have some level of sex offender registration post-conviction. Now, in Texas, regarding these kinds of crimes, and I'm going to focus on just the ones that will cause you to have to register. There are other offenses of a sexual nature, but today we're going to talk about just the sex crimes. These begin at indecency and go all the way up to continuous sexual abuse. Now, indecency with a child, you've got two different types. You've got by exposure and by contact. By exposure is a third-degree felony. It has a punishment range of 2 to 10 years if convicted, with a mandatory 10-year registration requirement post-conviction. Now, indecency by exposure is the allegation that the defendant removed the child's clothing for a sexual purpose. Not that he touched the child, not that they did anything to the child beyond removing the clothing. Okay? You also have indecency by contact. That is where not only has someone removed the clothing or reached under the clothing or on top of the clothing, but has touched part of the genitalia of the child, whether that be the vagina, penis, breasts, butt, any of those things. It can be over the clothes touching or under the clothes touching. That can satisfy that. That is a second-degree felony. It carries a punishment range of 2 to 20. Additionally, kind of lumped in here is sexual performance of a child. This is somewhat akin to indecency by contact or by exposure, but not quite to the level of indecency by contact. This is where the child has been videoed or displayed in a lewd or inappropriate manner. And, you know, this will also cause, if convicted, this will also cause a registration requirement. It fits in between the two, and so the punishment is not as egregious as a second-degree felony, but there are some little caveats in here, so we'll save that one for a different date to go into the actual details of it. Above indecency by contact, you then start moving into actual sexual assault. Now, sexual assault is any time that the defendant's genitalia penetrates the complainant's genitalia. For instance, and it can also go beyond that too. For instance, the penetration of the penis into the vagina is enough to get to sexual assault. The contact of the penis to the vagina is also enough to get to sexual assault. So there's a couple of different ways that the state can get there. But with regards to children, if the complainant is over the age of 14, then it will be a regular sexual assault, meaning that it's a second-degree felony, 2 to 20, okay, with lifetime registration. If the child is under 14 years of age, then it becomes a first-degree felony, with, 5 to 99 being the punishment range and a lifetime registration. Additionally, if the complainant is shown to be less than 6 years of age, it's still a first-degree felony, but it has a minimum sentence of 25 years going all the way up to life, and the availability of parole is removed, in addition to a lifetime registration. So, for instance, if the child is extremely young, when the jury goes, having found the defendant guilty, when they go to assess the punishment, they start at 25 years. And without the availability of parole, that means that if they only give 25 years, that defendant will do every single day of those 25 years before being released. Now, the highest offense in this category is continuous sexual abuse. And this is a very, very difficult offense to deal with, because typically what the allegation is that it is 2 or more instances of lower level offenses having occurred over the course of a 30-day period or more. So what you're looking at is any time the defendant is alleged to have repeatedly sexually assaulted or indecently contacted the complainant. It can also cover more than one complainant at a time. This is a very, very broad statute, and it covers a lot of different conduct. This one also comes with a punishment range of 25 to life, no parole. And it can be very difficult to deal with because the state, under the law as it is currently written, only has to list out multiple different possible instances of abuse. The jury does not have to specifically agree on any 2 of them. They just have to agree that 2 on that list occurred, even if all 12 of them came to 2 different ones. So long as they all agreed that there are at least 2 instances of some kind of, sexual indiscretion with a child on that list, then they can convict the defendant. There are some double jeopardy issues regarding this, which we won't really deal with here, but just understand that these kinds of cases are very difficult to defend. You really need to spend a lot of time working up the facts and circumstances to figure out where they can be attacked. You also need to be very much prepared for the punishment phase, even if you don't get there. The reason being is that if you do get to that punishment phase, the defendant is looking at a substantial amount of time, typically. And so anything that you can do to humanize the defendant and show that this is not everything about that defendant, the better off that defendant will be when and if that jury determines what sentence is appropriate. The other thing to keep in mind with any kind of sexual assault or sexual indecency charge regarding a child is that the state of Texas has gone to great lengths to make sure that that child's testimony is presented in the most efficient manner possible. There is nowhere else no other charge that I'm aware of where another witness can come in and testify as to what the complainant told them. Usually that's, kept out under a hearsay objection, but at least when we're dealing with children under the age of 14, the outcry statute allows any adult witness over the age of 18 who was the first person that this child disclosed this allegation to in some discernible manner, they get to come in and testify as to what they were told. Okay. Additionally, the sexual assault nurse examiner is going to just basically look over and take down the complainant's testimony. There may or may not be any physical evidence located, depending on how delayed this outcry was. But for medical purposes, it will be written down. Her allegation will be written down, and it will be testified to in court. So it's very important that you research the case and you know how to attack the credibility of these witnesses in an appropriate manner, because the state of Texas has set the rules so that it is much easier to get these kinds of convictions than it might be for something like a murder.